This presentation will guide you through special education law. So today we'll be looking at an introduction to IDEA. We'll look at ADA in Section 504, and throughout this presentation we'll be mentioning different types of cases that affected these two, and we'll be looking at some other case laws that have medical and discipline considerations. There are 6 features of the IDEA. FAPE, which is free appropriate public education, least restrictive environment, placement considerations, evaluations, parent-student participation, and the IEP. Just a little bit of history. IDEA stemmed from the original Education for All Handicapped Children Act, and in Raleigh versus Hendrick Hudson School District in 1982, this was the Supreme Court's first interpretation of this act and has become a standard analysis for every subsequent case. In this instance, there was a hearing impaired girl named Amy Raleigh. She was a student in New York who had minimal residual hearing and was an excellent lip reader. And the question was, what services were needed to provide education for Amy? So let's look at who is entitled to FAPE. And technically, it's all qualified persons with disabilities within the jurisdiction of a school district are entitled to a free, appropriate public education. And 504 defines a person with a disability as any person who either has a physical or mental impairment, which substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such an impairment. So all school-age children who are individuals with disabilities as defined by 504 and IDEA are entitled to FAPE. And how is an appropriate education defined? Well, education services are designed to meet the individual education needs of students with disabilities as adequately as the needs of non-disabled students are met, and it will include the education of each student with a disability with non-disabled students to the maximum extent appropriate to the needs of the student with a disability. And evaluation and placement procedures are in place to prevent misclassification or inappropriate placement of students with periodic reevaluations of students. The Timothy v. Rochester case in 1989, the United States argued that a school district may not refuse to provide a child with a serious disability a free, appropriate public education based on its determination that the child would not benefit from the educational services. Next up is least restrictive environment, and students must be educated with non-disabled students. And this was considered an absolute right. So a couple cases looked at that. Ronkner versus Walter in 1983, and the court developed a 2-part test for the appropriate placement for a student with a disability. This case was important and precedent for Daniel R.R. versus the State Board of Education in 1989, which relied on the Ronkner case for the 2-part test, which looked at can an appropriate education in the general education classroom with the use of supplementary aids and services be achieved satisfactorily, and if a student is placed in a more restrictive setting, is the student integrated to the maximum extent possible. Sacramento v. Rachel H. in 1994 dealt with a 3rd grade student with an IQ of 44 and her parents' argument that she should be educated in the general classroom. The court used the precedents of the other 2 cases, but they added an important caveat. They said the non-academic benefits of interaction with non-disabled students must be considered. So the effect of the student's presence on the teacher and other students must also be evaluated. This has become a 3-pronged test called the Holland test, and it's a standard in Nevada. Placement considerations are based on the IEP, and placement is in the least restrictive environment, and a continuum of alternative placement options is available to all students with disabilities. So it would start with the inclusion class or mainstream placement where the child is in a regular education class. The next level would be a resource room where students who need intensive help to keep up with grade level work in a particular subject can go to this resource room with a special ed teacher who works with a small group of students using specific techniques. Self-contained class where the child is removed from the general education population for all academic subjects to work in a small controlled setting with a special education teacher. There is also out-of-district placement where they are placed in a specialized school specifically designed to address special learning or behavior needs. And IDA provides a child the right to be placed only in this private school if a school district cannot provide an appropriate program. A couple of cases that a case that dealt with this was Pace versus Hannon, and this was actually the start of where if courts examined if IQ tests were not discriminatory. And looking at this, there was over 400 questions, and less than 10 were considered potentially discriminatory. So in this case, IQ tests were acceptable. Evaluations, IDEA states that the assessment of a child must occur to determine whether there is a disability, and there is an initial evaluation where that a parent must agree to. They have 60 days to receive consent for this initial evaluation. And if a child's primary language isn't English, they also can be evaluated in their native language or through a bilingual specialist or interpreter. And the assessment looks at cognition, academics, and language skills, along with social, emotional, developmental, and medical findings. It states that IDA states that a variety of tools must be used, and after the assessment is complete, an eligibility IEP meeting is held. Here, a team will discuss the results of the evaluation. And during this time, parent and student participation is definitely utilized because parental consent is required before the first evaluation. Parents are team members of the IEP, so they'll be looking at both the eligibility and the best placement for the child. Further, parents are also involved in reevaluation. They are given the opportunity to participate in all meetings. They should receive progress reports and look at revising the IEP. And likewise, there's also notification is required by parents if they want to file a due process complaint. So they must notify the SEA or the LEA, as the case may be. Students also have the opportunity to participate, especially beginning at age 14, but no later than 16. Transition services must be included in the IEP, and further, public agencies must now notify students as to their rights, if any, that will transfer them upon their age of majority. Procedural due process is a rule providing safeguards for students against school actions, including the right to sue. And so if for any reason a parent believes that their child is not receiving an appropriate education in the least restrictive environment, then they can take the following steps of action. There can be a resolution session, mediation, which is a meeting between parents and the state or local education authorities to settle their differences. Second would be the due process hearing, which is a mini trial before an impartial officer. And third, they could sue the school in state or federal court. Finally, the IEP is the individualized education plan, which the IEP team develops. And it is a written document and this process must occur at least once per year. It's designed to meet the unique educational needs of each student with disabilities. So IDEA requires that after drawing upon current evaluation information, the IEP team develops a written document, and in clear language it says the specific requirements or needs for the child that will be addressed in the educational plan. Let's talk a little bit about the non-discrimination issues in ADA and 504. Basically, the statute of 504 is intended to establish a level playing field. It usually by eliminating barriers that exclude persons with disabilities. So Section 504 precludes hurdles to participation, whether physical, like steps that prevent a person in a wheelchair from accessing a building, or something like excluding a child with hepatitis from a classroom. An important difference between the two statutes is who is protected by them. The definition of a disability under Section 504 is much broader than the definition under IDA. So Section 504 is less discriminatory. It protects all persons with a disability who have a physical or mental impairment which substantially limits one or more major life activities, have a record of such an impairment, or are regarded as having such an impairment. Substantially limits test. First, there's no quantifiable standard by which to apply the substantially limits test, And second, to determine whether students' learning is substantially limited, schools need to consider more than the students' grades. Both academic and non-academic activities need to be considered. Some other important case laws to look at. Plyler versus Doe in 1982. The schools public schools were prohibited from denying immigrant students access to a public education. The court stated that undocumented children have the same right to a free public education as U.S. citizens and permanent residents. Undocumented immigrant students are obligated, as well as other students, to attend schools until they reach the age mandated by state law. Doe versus Withers in 1993 is significant because it was the first special education jury trial and where dollar damages were awarded. In this case, Michael Withers, who is actually a state legislator as well, refused to make the oral testing accommodations required as stated in the IEP for a student with disabilities, and the student ended up failing the class and was athletically ineligible, and he was awarded, the West Virginia Circuit Court awarded the family $5,000 in compensatory damages and $30,000 in punitive damages for the teacher not making let me rephrase that. The general education teacher, the history teacher, was not making a good faith effort to provide required accommodations for a student with disability. Some medical cases, the School Board of Nassau County versus Arline 1987, and this case looked at whether contagious diseases are covered under 504. Cedar Rapids versus Garrett in 1999 examined what qualifies as related services under IDA. It includes medical services as long as the service is one not usually administered by a physician. Discipline might be an important consideration as well. Expulsion or suspension can occur with a student that has an IEP or is receiving services. After a child is removed from their placement, though, for more than 10 cumulative school days in a school year, services must be provided to the extent required under the provisions of FAP. A stay put provision actually came up in the Honig versus Doe case, which was upheld by the Supreme Court, which rejected the notion that there's something implicitly dangerous about stay put. And the stay put provision basically means that during the time when a school or law enforcement agency is reviewing the case or filing proceedings, a special education child has the right to remain in his or her then current educational placement unless the parent and school agree otherwise. If there is an immediate threat, then there's 45 days alternate interim placement. So in Mills versus the Board of Education in 1972, the court recognized that many children were being excluded entirely from education merely because they had been identified as having a behavior disorder. So this set the tone with that an individual can't be denied special education services. Thank you for listening to the presentation.